Thank you very much, Mr. Ambassador. And now we'll have John speak.
Good afternoon, everybody. It's wonderful to see so many people here today. I speak on behalf of my colleague Toby Cadman as well. It's very gratifying to see so many people demonstrating such interest in what has become for us an almost obsessive journey over the last few months to try and instill some sort of common sense into a tribunal, or the preparation for a tribunal, which thus far leaves such a great amount to be desired. Before I start, I must thank the American Society of International Law for having us. It's a privilege to be present at such an august institution, but most of all, I think it's only right that we record our thanks to Ambassador Rapp, because there is no doubt about it, he has had a significant effect, and he has made, he's rendered significant influence in slowing everything down in Bangladesh. A train which seemed to have run away out of control towards the end of last year has at least been shunted for the time being into a siding, and it's largely through his efforts. We're very grateful for that. Of course, it's quite strange sitting alongside Stephen on the same side of the fence, as it were, because he was my, I'm not going to use the word foe, he used that word, not me, but he was my chief opponent in Sierra Leone for some, I think, 3 years, the latter part of the RUF trial. So it's nice to be on the same side, as it were, after all that time. And I also have to endorse a comment that Ambassador Rapp made early on in his address, when he said, I think I got it right, he said, if international standards apply, it will mean so much more to the people and to the victims, referring, of course, to the tribunal observing international standards in purveying justice over the coming years. I'm an English barrister, that's my background. I would normally be wearing a wig and a gown. And so this is quite a departure for me. I left those at home for this trip. I often used to surprise juries in my opening, or my closing speech rather, by telling them a little bit about my role, my job. And they were rather surprised when I opened up by saying, it's not my job to get my client off at all costs. And it isn't. You will find some defence counsel, particularly in the international field, who appear to adopt the cause rather than the case. Toby Cadman and I don't do that. We are truly independent. And I'm saying this for the benefit of anyone who may be listening from the Bangladesh government, because we've taken a bit of stick from the Bangladesh government, or certainly their press sympathetic to the government, who have accused us of being part of a conspiracy, blah, blah, blah. We're not. I can remember that in one of the first times I appeared at the Old Bailey, I'm sure most of you have heard of that court in London, the judge made a comment which I'd never heard before. I'm sure a lot of you are probably familiar with it. Let justice prevail, though the heavens may fall. I didn't quite understand what that meant, but as time went by, of course I got it. Justice, fairness, at all costs. We must not save anything. We must not blanch at any expense in order to ensure that justice, fairness is not only done, but is seen to be done. And the reason Toby Cadman and I are involved in this case is to try to do our best, because we can't do any more than that, but to do our best to ensure that whatever happens is independent, is impartial, and it's fair. Because as Stephen Rapp said, if international standards of fairness are observed, it will mean so much more to the people and to the victims, because there were victims. I'm not going to sit here and contest the fact that there were atrocities in Bangladesh in 1971. And let me also say, I'm not going to sit here and say there shouldn't be a trial. But whatever trial there is, has to be fair and has to be consonant with current international standards of fairness. And it goes further than that, because one of Stephen Rapp's main objectives in Sierra Leone was legacy. The legacy really refers to reconciliation. This is a country that wants to become at ease with itself after years of being rent apart by hatred and violence. There are wounds which need to be healed. You can't heal those wounds if you coerce justice to do what you want to do, or to enact, or rather to realise your political ends. Because I'm afraid I have to say, being as objective as I can be, that the tribunal that's been set up in Bangladesh has all the hallmarks of a political show trial. And I will explain why. Something that really belongs back in Stalin's era in the 1930s rather than something in modern 21st century. And the government have a duty to legacy. They have a duty to the people. They have a duty to themselves. If this tribunal is enacted fairly and properly, it might bring closure on years of misery. It might heap praise and respect upon the government. It might place Bangladesh at the forefront of those pioneers in international criminal justice. It may set a magnificent precedent. But if you don't do it properly, it's not worth doing at all. If you don't do it properly, the precedent that is set is terribly dangerous. So what exactly am I referring to when I say it's a political show trial? Well, I don't want to be sensationalist. I'm not going to use those words again. I simply want to give you some examples of what the International Crimes Tribunal Act allows, and you can make up your own minds. And if I'm being partial, if I'm being unfair, if I'm taking anything out of context, then I welcome people to challenge me, because I want to be put right if I'm wrong. Ambassador Rapp has talked about the definition of crimes. I want to touch upon those to start with, and use this as an example as to why this tribunal necessarily has to have an international outlook. It cites crimes such as crimes against humanity, but it doesn't define them. And as Ambassador Rapp has said, the crimes against humanity were probably largely drawn from the old law in Nuremberg and Tokyo. But things have moved on since then. There is no reference in the Act to the definition of crimes against humanity. There's no reference to the need to prove something that's widespread or systematic and is an attack on the civilian population, for example. There is veiled reference to what we would these days refer to as joint criminal enterprise, the criminal mode of liability that is so often used in tribunals these days and has become a subject of great debate. There is no definition of the ingredients that need to be proved to sustain allegations of command responsibility, and yet that is cited in the Act as a way by which people can be convicted. The tribunal needs international assistance. It needs to have recourse to precedents, cases already ruled upon in international tribunals over the last 20 years in order to understand the very terminology that it propounds in its own Act. It needs international counsel, whether in court or behind the scenes. We're not particularly fussed about that. Obviously, we would love to be in court to do our jobs. But it needs international expert assistance, because this trial claims to be trying cases according to international law. It's as simple as that. It needs provision for training, not just for lawyers, but for the judges, who are equally, and I say this with all respect, uneducated in terms of the international concepts or legal concepts that the Act appears to be introducing. It requires monitoring. Why? Not as a disrespectful a blow to the institution, but because all tribunals have to be monitored. They all are. And it's through monitoring that a tribunal can make sure it stays on the straight and narrow. It's through monitoring that a tribunal can ensure itself